Hello and welcome to this knowledge clip on the jurisdiction of the International Court of Justice, the ICJ. At the end of this knowledge clip, you should be able to answer two questions. First, what is jurisdiction? And second, how is the jurisdiction of the ICJ established? The ICJ is, of course, not the only international court in the world. Apart from the ICJ, there are also, for example, the International Criminal Court, the International Tribunal for the Law of the Sea, the European Court of Human Rights, and other ad hoc tribunals. While all these courts and tribunals may be different, they all operate on the same foundation: states' consent. This means that international courts and tribunals only have the power or the competence to decide on a dispute brought before it if and only if the states that are parties to the dispute have consented to this. The power or competence of a court to settle a dispute brought before it is called the jurisdiction of the court. Again, as I mentioned, consent forms the most fundamental condition for an international court to have jurisdiction. How is the jurisdiction of the ICJ then established? In order to answer this question, we need to look at Article 36 of the ICJ statute. So let's do this. Paragraph 1 is provided, as you can see on the screen. Let's break this paragraph down. Look closely in this paragraph. How many ways can states bring a dispute to the court in paragraph 1, do you think? This paragraph provides for two ways in which states may consent to the jurisdiction of the court. First, all cases which the parties refer to it, and second, all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force. What does each of these mean? In the first way, the disputing parties may conclude an agreement in which the parties agreed to bring a specific dispute before the ICJ. This agreement is known as a special agreement. As you can see in this example of the special agreement, the parties specify the subject of the dispute and what they ask the court to decide. The special agreement is normally concluded after a dispute has arisen. The second way that the ICJ may have jurisdiction according to paragraph 1 is when a particular provision in an existing treaty or convention provides that a dispute arising from that treaty or convention may be brought before the ICJ. These provisions are known as compromissory clauses. Here you can see some example of them. The court's scope of jurisdiction is limited to disputes arising from that specific convention only. So, for example, if a state wants to use Article 9 of the Convention Against Genocide to bring a case before the ICJ, it cannot ask the court to decide on disputes relating to trade or law of the sea, for example. Now moving to paragraph 2 of Article 36, which you can see on the screen. Under paragraph 2, states accept the jurisdiction of the court by making a declaration to that effect. The unilateral declaration that states made are known as optional clause declarations. Here are some examples of optional clause declarations. As you can see, in some instances, when states make optional clause declarations, they can also make exceptions or insert some conditions to exclude certain issues from the jurisdiction of the court. These exclusions are commonly known as reservations to optional clause declarations. So if there is a dispute between State A and State B, they can bring the dispute to the court using Article 36, paragraph 2 if State A has made a unilateral declaration accepting the jurisdiction of the ICJ. Let's call this Declaration A. State B has also made a unilateral declaration accepting the jurisdiction of the ICJ. Let's call this Declaration B. Declaration A and Declaration B have to overlap in their scope of acceptance, or in other words, there is common grounds between A and B in the acceptance of the court's jurisdiction. When there is overlap in the optional clause declarations of two parties, the court will have compulsory jurisdiction. States are free to make these declarations or not. That's why they are called optional clause declarations. But once the declarations are made, the jurisdiction of the court based on them is compulsory. The final way in which the ICJ's jurisdiction can be found is forum prerogatum. The basis for this means is not found under the ICJ statute, rather it finds its basis on Article 38, Paragraph 5 of the rules of the ICJ. Forum prerogatum may serve as a basis for the court's jurisdiction in the case that a dispute is brought against a state which has not recognized the jurisdiction of the court at the time the proceedings are initiated. However, subsequently, the state accepts such jurisdiction by filing their memorials and appearing before the court. This was the basis for the court's jurisdiction in, for example, the case between Djibouti and France, in which France decided to accept the court's jurisdiction, but only for that particular dispute. So, to recap, 3 pieces of information to take away from this knowledge clip. First, jurisdiction of the court is the competence of the court to hear a dispute. Second, jurisdiction is and has to be based on the consent of the parties to the dispute. Third, there are 4 ways for states to consent to the jurisdiction of the ICJ, and these are by concluding a special agreement, by being parties to a convention that contains a compromissory clause, by making a declaration which accepts the jurisdiction of the court, and finally, forum prerogatum, by agreeing to participate in the proceedings on an ad hoc basis. Now go back to the beginning of this knowledge clip and see for yourself if you can answer the 2 questions that were raised there. Good luck!